So I think we had talked about authorized representatives in the last class. Right. I remember stating that authorized representatives, for a lot of practical purposes, they are same as providers, and hence their obligations are very similar to providers, right? So we had talked about this, no point repeating this. Now we come to the obligation of importers. Who are importers, by the way? Who are importers? See, in today's world, I mean, as of today, if you just know these terms, you are far ahead of so many people. So many people in the sense, the early you start into this consulting, the more money you can make. ये भी हटाना पड़ेगा मेरे को.
इंपोर्टर्स को होते हैं जो क्या होता है, जैसे ओपन एआई है, वो यूएस में चलता है, तो मैंने उस मॉडल को इंपोर्ट करके इंडिया में अपने नाम पे रजिस्टर करा के चलाने लगा हूं, लाइक ओला का.
Right. So देखो, why do we have all these things? Providers, authorized representatives, importers, what are the other things? Distributors. So operators is combining everything, and deployers, right? Why do we have all these terms? Because different parties play different role. So providers, if they are inside EU, you don't have to talk about so many things. Maybe provider and deployer are sufficient. Okay. If you talk about, so that is one case. Another case is provider is not in EU. So in that case, you have to have importer, authorized representative, and so on. So now we are talking about obligations of importer. So importer is someone who is importing the technology from outside EU. That means provider is not inside EU. Okay. So the law must put some responsibilities on someone. So in that case, that is importer. Now, before placing a high risk system onto the market, importers of such system shall ensure that such a system is in conformity with this regulation by verifying that these things. Now tell me, why are we just talking about placing a high risk AI system here and not putting on the market? Or not putting, what was that phrase? Placing onto the market or putting into service. Thank you. So why are we not talking about that? Think over it. Now before placing a risk on market, importers of such system shall ensure that such a system is in conformity with this regulation by verifying what? The relevant conformity assessment procedure referred to in Article 43 has been carried out by the provider of that AI system. So I am not going into what is the procedure in Article 43, but what does this line say? That the relevant conformity assessment procedure, so it is an obligation of the importers. The importers of such system shall ensure that such a system is in conformity with this regulation by verifying what? That Article 43 has been carried out by the provider of that AI system. What is it? Is importer a provider? Is importer a provider? No. Importer is putting technology of someone else in EU. So the importer is supposed to verify that the conformity assessment procedure referred to in Article 43 has been carried out by the provider of that AI system. So it is just supposed to ensure that provider has done this part of its obligation. The provider has drawn up the technical documentation in accordance with Article 11 and Annexure 4. So again easy. In this, if you see, paragraph 1 just says what is importer supposed to do? Just to verify these things. So it should verify that the provider has gone through this procedure, that the provider has drawn up a technical documentation in accordance with Article 11 we talked about. So, what was Article 11 talking about? Article 11 was in which chapter? 2. And what was the title of the chapter? The requirements for AI system. Okay. Article 11 was technical documentation. So, again, importer is supposed to verify that the provider has done that. The system bears the required CE conformity marking and is accompanied by the EU declaration of conformity and instructions of use. So, again, importer is supposed to verify that provider has complied with this requirement as well. That the provider has appointed an authorized representative in accordance with Article 25(1). Okay. So, who is supposed to verify this? Importer. Now, where an importer has sufficient reason to consider that a high risk AI system is not in conformity with this regulation or is falsified or accompanied by falsified documentation, it shall not place that system onto the market until AI system has been brought into conformity. This is also simple. What does it state? So, as an importer, if you have reasons to believe that the AI system is not in conformity with this regulation, then it shall not be placed on the market first of all, and you have to also make sure that until it has been brought into conformity. So, when you place it onto the market, if you place it onto the market, it should be in conformity with the regulation. If it is not, do not place it. This is what it means. Where the high risk AI systems present a risk within the meaning of Article 65(1). See, this Article 65(1) is popping up again and again, and this Article 65(1) basically means risk not necessarily at an individual or at a group level, mostly at a national level. So, much bigger impact. The importer shall inform the provider of the AI system, the authorized representatives and the market surveillance authorities of to that effect. Okay. So, where AI risk system presents a risk within the meaning of this. So, in this article they define risks of specific kinds. Importers shall indicate, so this clause 3 is just saying whereabouts of importers. We also did this for what? If you remember, when we were talking about providers, we said even providers have to give all this information. When I was, again and again taking example of this kind of a box, you have to put all these, your name, trademark, all this information. So, importers shall indicate their name. Now, shall, what does shall mean in legal language? Mandatory. Okay. So, importers shall indicate their name, registered trade name or registered trademark and the address at which they can be contacted on high risk AI system and on its packaging or its accompanying documentation wherever applicable. So, for example, if importer does not do this, is importer violating this law? If importer does not do all this, is it violating a law? And is it liable to be prosecuted? That is what a law means. Law says you shall. If this is not done, then you are violating this law and hence you will be prosecuted according to the provisions of this law. Importers shall ensure that while a high risk AI system is under their responsibility, where applicable, storage or transport conditions do not jeopardize its compliance with the requirements set out in chapter 2 of this title. What does this mean? But why is this coming at all in this? This was not there before. We have seen this for the first time. Why? Right? Because provider, if it was in EU, there is no question of this part. But now provider is in some other jurisdiction, you are bringing it to EU, importer can't take this defense. See, so provider will say we are doing everything fine, importer will say we are doing everything fine. Now if importer takes this defense that while transmitting something got corrupted or whatever, you can't take this defense, because the importer, it is the duty of the importer that it shall ensure. If it does not, again you are in violation of this law. So the importer shall ensure all these things. You can't take this defense that whatever happened, it happened during transmission from country X to country Y in EU. Importer shall keep for a period ending 10 years after the AI system has been placed on the market or put into service a copy of the certificate issued by the notified body where applicable of the instructions for use and EU declaration of conformity. So keep it for 10 years, that is what it is. So importer shall provide national competent authorities upon a reasoned request. This is I like about EU. So authorities are given power, but they are not given absolute power. So upon a reasoned request. Now who will decide whether it was sufficiently reasoned or not? Some court of law will decide, because authorities say we have given sufficient reason. As a company we say you have not. Then who decides this dispute? A court of law. Upon a reasoned request with all the necessary information and documentation, including that kept in accordance with paragraph 4A to demonstrate the conformity of high risk AI system with the requirements set out in chapter 2 of this title in a language that can be easily understood by them. So this can be actually daunting. In practice it won't be, because things will be in English anyway. But let's say if company is in the US and if Romania says we want everything in Romanian, then that's an extra burden on the company that is located in US, because if you give everything in English, then you don't have to do anything, but in a language which can be easily understood by them. So I am pretty sure they won't make it difficult for the companies by keeping only those people who don't speak English or understand English. To this purpose, they shall ensure that the technical documentation can be made available to those authorities. So basically what it means, keep documentation for 10 years and provide it to competent authorities whenever asked, provided you are given a reason why are they asking. Importers shall cooperate with national competent authorities on any action those authorities take, in particular to reduce and mitigate the risk posed by the high risk AI system. What is this? Have we seen this before? Have we seen this before? Such obligation was for providers as well, but it was in a separate article there. So see, providers had a lot of obligations. Let us go there once. So see, obligations of providers started from here, okay? And then after mentioning all these things, we said that they must have a quality management system. Then we talked about a documentation keeping. Then we talked about automatically generated logs. Then corrective actions and duty of information. What is this? If you find some, so if provider considers or have a reason to consider that their HR high risk AI is not in conformity, then you have to take the corrective actions. All these things are for providers. Providers should cooperate. Authorized representatives, there will be a thing saying here somewhere that authorized representatives should cooperate, and similarly for importers as well, as we have just seen. Okay. Article 27, obligations of distributors. By the way, today EU Parliament has a voting for this one. So, in all probabilities it should pass. Before making a high risk AI system available, so now we are talking, importers are done, now we are talking about distributors. Who are distributors? I don't. So, distributor, you know, should mean something like if you are none of the above, something like that. But so, distributor means any natural or legal person. So, this is important. Any natural or legal person. By the way, what is the difference? Any natural or legal person? We have talked about this before. Natural person means a human being. Legal person means can be a company, can be government, okay, can be authority. Legal person basically means who can be sued and who can sue you. Okay. So, where is that distributor? In the supply chain. So, right, other than the provider or the importer that makes an AI system available on the union market, right. So, why did we have this distributor? We talked about this before, that some third party can take this defense. See, I am not a provider, I am not a importer, and hence this regulation does not apply to us, but now they can't circumvent this, because if you are none of these two, then basically you are distributor. And the operator means provider, product manufacturer, deployer, the authorized representative, the importer or the distributor. So, operator basically means everyone. Right. So, obligations of distributors, those who are neither providers nor importers, but they are still placing the AI on the market. Before making a high risk AI system available on the market, distributors shall verify that the high risk AI system bears the required CE conformity marking, that is accompanied by a copy of EU declaration of conformity and instructions of use, and that provider and importer of the system as applicable have complied with their obligations set out in Article 16.AA, B and 26.3. Okay. So, what is this statement overall? Right. So, since as a distributor you do not have the full responsibility, you are not developing that. So, you should ensure that whosoever, so distributor shall verify that high risk AI system bears conformity marking and is accompanied by the copy of EU declaration of conformity. So, before as a import, before as a distributor you put something on the, you place something on the market, ensure that these things are happening. Shall verify. Right? As a distributor, if you do not verify these things, later you can't take this defense. So, let us say that particular AI was not having this part. As a distributor, you can't take this defense in a court of law that I did not know this. You were supposed to know it, you were supposed to do it. With the obligation set out in Article 16.AA, which is basically whereabouts. Article 16 was for Importer or provider? Provider. So whereabouts of the provider. This talks about the quality management system obligation, and this is the whereabouts of the importer. So since you are distributor, that means you are neither provider nor importer. So you should have whereabouts of both of them, provider and importer. Where a distributor considers or has reason to consider, what do we see coming? Just by reading this, you can tell me what is coming. Where the distributor, don't read further. Where a distributor considers or has reason to consider. Consider what? That this regulation is not in conformity or with this, then don't place it onto the market. First ensure that this is in the conformity with the law, right? This is what it should mean. And then later, wherever they say this kind of statement, most of these things are copy paste now if you see that pattern. So they will say this, and then they will say, if distributor thinks that it presents risk within meaning of article 65(1), then distributor shall inform other people too. What was 65(1)? Risk is much broader, right? It is not national security. The risk is on national level. Distributors shall ensure that while a high risk AI system is under their responsibility, where applicable, storage or transport conditions. What is this now? We have seen this before. So just change this word to importers and it was the same, right? Because something is under your responsibility, you can't take this defense that something happened while you were transmitting data from one jurisdiction to the other. What is coming? Right. Right. What is the difference? It is exactly the same. By the way, this particular document still had a couple of mistakes, but there is no mistake here. What is the difference? This says shall not make the AI system available if it has reasons to believe that some things are wrong, in particular not in conformity. Here it says it is already made available, but later you think something was wrong. So if you have reasons to believe on the basis of information that a high risk AI system which is made available on the market, in this case it was before you place it onto the market, now it is already placed, but now you have reasons to believe, then you shall take the corrective necessary actions to bring the system into conformity with those requirements, to withdraw it, to recall, to ensure that the provider, importer or any relevant operator takes those corrective actions. And now what do you see again? If this poses risk in the meaning of article 65(1), then you have to tell everyone, where everyone is competent authorities, the importer, the provider and so on. Upon a reasoned request from national competent authority, we have seen this before. Which one? कौन सी बात कर रहे हो?
प्रोवाइडर ने हल्का सा उसको मॉडल को ऐसा करने के लिए ट्वीक किया, अब डिस्ट्रीब्यूटर तो प्रोवाइडर पे क्या होता है बिलीव कर रहा है या इंपोर्टर बिलीव कर रहा है,
ओके,
तब तो सब फॉल केसेस करेंगे ना, कोई किसी ने हाई रिस्क किया, किसी ने भी छेड़खानी करी, सभी मारे जाएंगे।
सभी कौन?
जितने भी ऑपरेटर हैं,
See,
जितने भी
provider is outside EU. You can't really cast a lot of responsibility on it. It is for this reason, see,
but sir we know that Google को sue करते ही क्या आता है कि और उसको पैसे देने पड़ते हैं million or billion of dollars. तो
okay, so from what I know until now, EU has put a lot of fines on these companies. If I remember it right, it was 850 million on Amazon, somewhere around 750 million, and we are talking about in dollars, on Google. But from what I know, nobody has paid until now. Okay, maybe you can check it. My last knowledge, whenever I read this, it was said, okay, so they have imposed this fine, but nobody has paid until now.
but they can impose big numbers.
Yes.
उनकी economic crash होने वाली होगी तो सारे को sue कर दे $100 million हो गया बस.
Right. That is why US companies are saying this law is basically to bash US companies. Because in the end, almost nobody in Europe is doing it. So only 3% of the AI unicorns are from Europe. Most of them are either from USA or China. So you are trying to regulate, which is present only 3% in your economy. But I still very much I still like this particular regulation a lot, because the way things are being done today, everybody is calling everything, whatever they are doing, as AI. Right? So there has to be some kind of reasonable checks and balances to this madness. Everybody is doing whatever they want to do. So distributors shall cooperate. Upon a reasoned request, you have to give information to national competent authority and so on. This was corporate, this was we have seen already. Now, so distributors are over. Responsibilities along the AI value chain. Now, so we talked about providers. Providers, how many articles were there for providers? 16, 17, 18, there is no 19 in this document that we are seeing, 20, I think 21 or 22, one of them is also missing, then 23, 24, 25 was for authorized representatives, 26 was for importers, 27 was for distributors, and now we are coming, so we have talked about all these, whatever remains we talked about now, along the AI value chain. So any distributor, importer, deployer or third party shall be considered a provider of high risk AI system for the purpose of this regulation and shall be subject to the obligations of providers under Article 16 if any of the following circumstances are met. So this does not happen automatically in all conditions, but these conditions have to be met. They put their name or trademark on a high risk AI system already placed on the market or put into service. So if you start claiming by putting your trademark that this is your system, then basically you become the provider. Okay? They make a substantial modification to an AI system that has already been placed on the market or has already been put into service in a way that it remains a high risk AI system in accordance with Article 6. What is this? See, this is very simple. If you call something this is yours, then you become the provider. It does not matter whether you did it or not. Right? What is this? So anyone, distributor, importer, any third party other than provider, if they make substantial changes to so there was a high risk AI system that was already placed on the market, you make changes such that it still remains a high risk, then you become the provider. Make sense? Because you have made the substantial modification yourself. So any distributor, importer, deployer or any third party shall be considered provider if these conditions are met. So if you put a trademark saying this is your thing, then you must be the provider because you are owning it. Second is, if you make substantial modifications to whatever that was already existing, to a high risk AI system. So, something that was already high risk AI, you make substantial changes to it and it still remains high risk AI, you become the provider because you made the substantial modification.
Who will modify this substantial?
Courts, right? So, you can't really quantify this thing in a generalized manner. It has to be taken case by case. In any legal setup, if you see wherever something has to be taken in a case by case manner, words like substantial, reasonable, these will be there. And courts will decide what does that particular term mean in this particular condition. What?
If after modification the AI is not high risk anymore, then also the
If it is not high risk AI anymore, so everything applies to what? High risk AI. So this does not apply. Okay. They modify the intended purpose. Okay, what is this last one? You should be able to explain me this now. They modify the intended purpose of AI system, including a general purpose AI system, which has not been classified as high risk and has already been placed on the market or put into service in such a manner that the AI system becomes a high risk AI system. So you are not putting your label, you are not putting your trademark on it, you are not modifying it substantially. What is this third case? You are not supposed to change it. See, if you just modify the intended purpose, so the example is exactly the same that you were saying, right? So if your intended purpose becomes such that it becomes a high risk AI, then also you are the provider because the original provider did not have this intended purpose. Okay. So where the circumstances referred to in paragraph 1, the three conditions that we just talked about, point 8 occur, the provider that initially placed the AI system on the market or put it into service shall no longer be considered a provider of that specific AI for the purpose of this regulation. Okay? And this is what it means. Rest are details. This former provider shall closely cooperate and so on. This is fine.
Sir,
हाँ.
मैं OpenAI का हूँ, बैठा हुआ चाहता है कि आराम नहीं होना चाहिए। मैं क्या होता है?
नहीं, see now. You know Vodafone case of India? You know Vodafone case? Where Vodafone actually owed $2 billion as taxes to Indian government. Now, $2 billion is huge, right? So, I mean that will take me away from this and I don't have that much time. We can take it after the class, okay? So, they did exactly the same, opened a shell company somewhere outside and so Indian government said no, it is Vodafone who must pay the taxes, not that company. So, if a jurisdiction says you must do something, see, if Indian government today says Google should do this, Google does that. Google has to do it because you can't afford to leave a marketplace of 1.5 billion people. Right? So for example, if you ask Gemini about, this is controversial, but okay, this I can say, if you ask Gemini about President Xi Jinping, it will say whatever, because Google is banned there, right? So you know you can't harm Google more than this. So Gemini will say whatever, but if you ask it about Putin, it won't say anything. If you ask it about India's PM, it won't say anything. If you ask it about whatever, it won't say anything, but about Xi Jinping, dictator, this, that, everything. Now, for high risk AI systems that are safety components of products, which, okay, what is this saying? So for high risk AI systems that are safety components of products to which legal acts related listed in Annexure 2 Section A apply, the manufacturer of those products shall be considered the provider of high risk AI system. So this is for the first time we are seeing where manufacturer is being treated as a provider. Okay. So manufacturer of what? Remember we talked about these things they were talking about. So for example, if you are making a AI enabled braking system in metro, so then the manufacturer who is making that AI enabled braking system becomes the provider. The high risk AI system is placed on the market together with the product under the name or trademark of the product manufacturer in that case also, right? Okay. And the high risk AI system is put into service under the name or trademark of the product manufacturer after the product has been placed on the market. So you do it before or after, you still become the provider. I don't think I will be able to cover deployers today. Let us see, we will try to. What is this now? The provider of a high risk AI system and the third party that supplies an AI system, tools, services, components or processes that are used or integrated in a high risk AI system shall again by written agreement. So if you don't have a written agreement, you are in violence of the law. Specify the necessary information, capabilities, technical access and other assistance based on generally acknowledged state of the art in order to enable the provider of the high risk AI system to fully comply with the obligation set out in this regulation. That means if you are manufacturer of something, for example NVIDIA, okay, and if providers are making AI on your hardware, so you as a company, you as a manufacturer should make the compliance of this particular regulation easier for the provider, should not hinder it, that's it. Now AI office may develop something more, that is fine. This is super important thing, even though this is just one sentence. Anybody knows about this when not Times of India, when New York Times sued OpenAI? Are you aware of this suit? Yes. Right? Now there are so many suits of this kind. Now in EU, they are clearly writing it in the law itself that if you violate copyright law, then you are in violation of this act. Whereas in US, they are debating what is more important. The protection offered by copyright laws or advancement of AI. So you as a creator are being crushed because people will train their LLMs on your data, will not pay you anything for it. If they pay you, you are fine, but without paying any money, they build a machine that starts generating money for them. So you are basically taken on a free ride, right? They don't pay you anything, but they themselves are making money from it. So OpenAI suit is a very, very interesting suit. I'll cover that. I think it's a good idea not to start this. This is an important one, and we'll do this one and the fundamental rights impact assessment in the next class.